County of Sheboygan, and we are providing public access to this hearing both in the courtroom and also online. And up next, we have Sterrett v. Benson, file 24-9023CZ. Counsel, you want to state your appearances for the record, beginning with plaintiff.
Good morning, Your Honor. Kevin Cleaver, and I represent Michael Sterrett, who's to my left. Francis Sterrett is in hospice, is not present today. We'll also have David Sterrett, the one who signed one of our affidavits in the rear of the court.
Okay, thank you. Good morning.
Your Honor, Kurt Thornblad on behalf of Dr. Philip Benson. Mr. Benson is also present on Zoom. The court indicated that the hearing today would be on Zoom.
Okay, thank you. And yes, Mr. Benson is in the hearing. His audio's on, his video's not on, and that's certainly fine with me. All right, so this is plaintiffs. We're up for a final pretrial, but we have plaintiff's motion for summary disposition. I have reviewed the motion, response, and reply, and all of the attendant exhibits. Thank you both for setting forth the facts and the law in a way that I could understand what the case was about. So, Mr. Cleaver, go ahead and argue your motion, sir.
Thank you. Your Honor, I think I would probably be well advised to do the counterclaim by the defendant first. It was filed after we took his deposition. It was clear in his testimony that there was certainly a long period where he was kind of missing in action, but most importantly, his counterclaim that repeatedly said everyone used this cabin, everyone had a key, et cetera, certainly shows that there was no exclusive use, there was no hostility. And so I just didn't see any substance at all to the counterclaim. And so that's why we asked that the counterclaim that was just filed July 3rd be dismissed. If there are any other questions about that, I'm happy to engage, but I thought I'd spend most of my argument time on the delivery of the deed issue.
Sure, I think I understood his argument on the counterclaim to basically be, because we've got a little bit of a weird factual crevice that this case fell into, that for the last more than 20 years, everybody has believed the two plaintiffs and the defendant to be co-tenants because of the deed, and the problems with the delivery weren't revealed until much later.
Right.
So I understood his counterclaim to basically be some kind of way to attach a legal theory to acknowledge that if I've been treated as the owner for 20 years, shouldn't I be the owner? Why should that not be?
Well, I thought that was more of an estoppel argument as opposed to an adverse possession claim. I thought his claim with regard to acquiescence, that's a boundary dispute. The acquiescence theory does not apply at all in this case. So I thought his estoppel argument may have had more wind in the sails, if you will, if again, the defendant had been chipping in his 1/3 over 25 years.
Or if your clients had known about the delivery problem and done nothing about it.
Correct. And if then, he chipped in his 1/3 and now we raise the issue of the delivery of the deed, well, I can understand an estoppel argument better then, but he hasn't been chipping in. And so I just thought that the estoppel argument didn't resonate with me anyway.
Okay. So can I ask you, so you're, and maybe I'm jumping the gun getting into your main claim. My principal question is, so there's this deed that puts your two clients and Mr. Benson as co-tenants, that then appears to be undisputed that deed was never recorded or delivered to any of the grantees before the grantor's death.
Correct.
And so black letter law would be that deed was in effect. So, and you've attached a will that would have your two clients be the devisees of that property. And as I understand the law, black letter law, that the property would transfer at the title of the real estate passes at death to the heirs or devisees. But was this will ever probated, or?
There was a Wayne County probate action that was opened up, and then it was closed administratively in about 2005, 2006, somewhere in there. I just checked the register of action in Wayne County.
But
and
the
so-
will was submitted to probate.
Correct, it was. But once, by 2004, 2005, when this deed sort of appeared, they just sort of abandoned the probate claim and let the probate court in Wayne County close out that proceeding.
So if you prevailed on count 4 is to declare the deed invalid because it was not delivered or recorded before the grantor's death.
Well, that was correct. And I guess I didn't see that the affidavit that was, again, whether it was signed in front of a notary or not, that's more of a technical issue, but the defendant repeatedly testified that he knew absolutely nothing about the deed, didn't even know where it was, didn't know who had it, etc. And it was only 25 months plus after it was recorded. It was again recorded 25 months after Wileen Starrett allegedly signed it, that his mother showed him a copy of it. Well, and again, I covered that ground as thoroughly as I could, and then to have an affidavit say, well, gosh, Wileen gave it to my mom. Well, he didn't testify to that. He had no idea whatsoever where that deed was. And so that's why we, in our reply, said that's just a bad affidavit. You're trying to, grasp a Hail Mary pass here to avoid summary disposition.
If you prevailed on count 4, what would that do to your remaining counts 1 through 3?
Well, I think the only thing that we would have is, again, our original complaint pled the statute with regard to the court, I think, would need to issue a writ of restitution type thing with regard to restoring possession to us. Again, the affidavit of Janelle Russian, for example, last week, it was just fortuitous that when we got in the reply brief that she was up here staying with my client, Mike Starrett, she would have used the cabin, but for the defendant's occupancy. And so I think under the statute, section 3 of MCL 600.2932, the court can issue, writ of possession restoring us. And then even under the court rule 3.441, I think it's sub C, the court can set a hearing with regard to his possession as squatting, if you will, over the last year.
Sure. So that goes to what remedy you're seeking.
Correct.
But my question is, you had 3 other counts for contribution, for adverse possession.
Yeah.
So if you win relief on count 4, counts 1 through 3
I think the rest are
are
academic.
moot. Okay.
Yes, I think they're academic.
So my other question would be, if you prevailed on count 4 and the deed is invalid, and I imagine then a judgment, you'd want quieting title in your clients. Would that be tenants in common then, because it would have passed through a will, and then if they want some other co-tenancy, they'll have to execute the
I believe that
necessary
would be correct.
documents?
Yes, that would be the result under the will. Anyway,
Okay.
yes.
I didn't mean to short circuit you.
No,
Anything else you want to argue with that? Go ahead.
I
I just.
frankly rather scratch where you itch than just yammer on without any kind of, I guess I think the only thing I guess I would draw the court's attention to is plaintiff filed this motion, and then the defense in their response raised, again, a number of issues. One of the cases that they quoted, Cook versus Sadler, they quoted it 4 different times. I think trying to argue that a mysterious delivery of the deed, who knows, to the defendant's mother somehow was an escrow type thing. And so, again, because they quoted it 4 times, the only comments I'll make about Cook v. Sadler against a 100-year-old case. But in that particular case, there was a delivery of a deed with specific instructions. Don't record this until after my death. So A, there were specific instructions. We have none of that in this particular case. The father and mother actually told the son at issue, we're going to do this, son, and it'll be recorded after death. So there's none of that in this particular case. The son went ahead and built a house on the property, and then he planted orchards on the property in reliance on that. So it was kind of, again, an estoppel type case. And so, again, I just didn't think that, A, the escrow argument had any kind of merit, but again, it was more in that particular case that they quoted 4 times, the son actually relying on what was promised. So I just thought that that was a case that should be distinguished. So anyway, that's the only comments I'll have. I'll wait till defense counsel responds and save my
Okay.
time for that.
Thank you, Mr. Cleveland. Mr. Thornblad, what's your response?
Well, Mr. Claiborne wants to do the adverse possession issue first, so we'll do the adverse possession issue first. But I'll also reference the theory of that you can give a deed to an agent in order to record it or deliver it later on. Now, obviously, the grandmother gave my client's mother access to her paperwork, and that's pretty well established. And then the mother went forward and recorded the deed. Now, we have in this state what's called a presumption, which favors the defendant in this case. That's a presumption of legality. So it would be presumed until it is shown otherwise by the plaintiffs that the mother was acting under the direction of the grandmother. But even if it were not the case, even if that were not the case, to get back to adverse possession, it's still a color of title. It's an open and notorious act that was done more than 15 years ago. A number of people in the family have used the property, but that's consistent with the grandmother's general proposition that the title to the property should be held generally insured and used by those who need it. The acquiescence theory goes to.
Can I ask you? If the use has been communal, how could that establish adverse possession against co-tenants?
That's the acquisition theory under the case of Houston versus Mint Corporation, and it's also consistent with the doctrine of tacking. So my client may not have been in this property for 15 years, but he can tack onto the usage of other people, and that's the same as the acquiescence theory.
Okay, thank you. Anything else you want me to know to understand your argument, sir?
Yes, I will. Even if it's not a proper deed, it's still a testamentary statement, and deeds have been used as testamentary declarations. I would add that if, in fact, Mr. Claiborne and his clients prevail on this issue that there is no valid deed, then his clients do not have any standing to come forward. It has to go back to the probate court. You can't quiet the title. Other things can come up. The deed is dated after the will that's being cited by the Claibornes. The later testamentary act is the one that governs. It has to be if you decide as a matter of fact today that the deed is an invalid deed, then nobody has title to the property until it goes through the probate court.
All right, thank you. Any rebuttal, Mr. Cleveland?
Thank you, Your Honor. Now, obviously, on the deed issue, it is the burden of the defendant to prove delivery of the deed. If he's going to rely on it, he has to prove it and show that to the court's satisfaction, and there's really nothing whatsoever. With regard to the adverse possession claim, when the defendant at his deposition testified that after his grandma died, there was social drinking that offended him, and he, quote, never spent a night there. Well, again, that just kind of boggles my mind that you can advocate then an adverse possession type claim. And then lastly, with regard to the testamentary nature of a deed, I mean, that argument just makes no sense when Wileen retained a life estate. I mean, there was nothing on the deed that said it's going to take effect, you know, when I die and when I die only. So I just can't appreciate that argument. So again, lastly, the Houston case. That's why I attached a copy of the survey and the picture. It's an acquiescence boundary line dispute case. You know, it's the garden was over the line, and so acquiescence just has no relevance whatsoever to this proceeding. And I ask the court grant our relief.
All right, thank you. Well, there are some facts for which there's no real genuine issue here, as follows. On July 28th of the year 2000, there's a quitclaim deed from grantor Wileen Sterrett to 3 grantees, the 2 plaintiffs and the defendant. and reserving to the grantor a life estate. And also that deed was not delivered to any of the three grantees before the grantor's death. The deed was not recorded until August 26th of 2002, again after the grantor's death. The defendant's deposition testimony establishes that he was unaware of the deed until after its recording, and he did not know where it was before then. Defendant now attempts to contradict his sworn testimony by an affidavit that the plaintiff says is improperly signed. But even if it were properly signed, this is not permitted to fix. You can't fix your deposition testimony under oath by just submitting a written affidavit saying nuh-uh. And also the claims contained in that affidavit were flatly contradicted. The claims in his affidavit about what Ms. Ruskin said were flatly contradicted by a properly executed affidavit from Ms. Ruskin saying, no, I never said that or never understood that. Also from 2002 onward, the defendant did not use this property much at all. There were reasons why he didn't want to be there relating to alcohol use or other things, or reasons personal to himself. He didn't want to be there. He also did not contribute toward the upkeep expenses in any significant way, perhaps an isolated instance or de minimis fashion. Didn't carry his share of the load as one of three co-tenants under that deed. After apparently sometime during or after the COVID situation, defendant was evicted from a home and has used the cabin as a residence in a manner that has prevented its communal use by the plaintiffs or by other family members. So those appear to be largely undisputed facts. The legal analysis would be that the deed that was undelivered and unrecorded before the grantor's death was in fact ineffective to convey any property interest. A deed must be delivered to be effective. The defendant tries to argue that it was placed in some sort of escrow and therefore delivered, but the facts don't support this theory at all. There's no evidence or testimony or any indication of any escrow agreement or any terms of what that escrow would have been. In fact, and this ties into the defendant also says the deed was testamentary and is therefore an amendment or codicil to Ms. Sterrett's will. But there's nothing on the deed or in the record to support this claim. In fact, the deed on its face reserves a life estate to the grantor, which would be nonsensical if the deed was not intended to convey a present interest to the grantees at the time of its execution. So there's evidence that would show that it was not a testamentary deed because it reserved life estate to the grantor. There's no evidence of any testamentary intent, merely an executed deed that was neither delivered nor recorded until after the grantor's death and therefore legally ineffective and a nullity. Defendant argues the plaintiffs should be stopped from raising the delivery issue, or that they've acquiesced in the joint ownership of the property over these 20 plus years. Estoppel would be an equitable application, and here the plaintiffs did not know about the lack of delivery until this litigation, and defendant has not contributed in any meaningful way to the upkeep of this property. So there's no equitable basis to apply estoppel here. And the doctrine of acquiescence is simply inapplicable. Acquiescence is a judicial doctrine to resolve boundary line disputes, and this is not one of those. Defendant also asserts adverse possession, but by his own testimony, he's not used what he calls this communal cabin exclusively. He may recently be doing so, but this recent use falls far short of the 15-year statutory period. Wileen Sterrett's will left this property to the two plaintiffs themselves. And the recent case of in re petition of Emmett County Treasurer 345 Mishap 692 in 2023 clarified, what I had always understood to be the law, but they flatly stated that yes, title to real estate passes at death to the heirs or devisees. The will still has to be admitted to probate, which apparently was, but there's nothing that the probate court does, that effectuates the transfer passes upon death. So therefore, under MCR 2.116C10, there's no real genuine issue of material fact here, and plaintiffs are indeed entitled to judgment as a matter of law as to count 4 of their amended complaint, striking the deed for the lack of delivery. And as the plaintiffs indicated, this renders their counts 1 through 3 unnecessary. Plaintiffs are also entitled to judgment as a matter of law on defendant's counterclaim for adverse possession, which is dismissed with prejudice. So the plaintiffs are entitled to a judgment that would strike the deed, would quiet title in them and them only as tenants in common under the will, and order the defendant to vacate the premises immediately, and rendering the defendant responsible for any damage or waste of the premises. And the court would, that judgment, when entered, would close the case and be a final order, but the court still would, of course, retain jurisdiction to facilitate the adherence to the court's judgments. Mr. Cleaborn, you can submit a judgment either by stipulation as to form or under the 7-day notice. And Mr. Cleaborn, Mr. Thornblog, would take you both.
Thank you.
Thank you, Your Honor.
All right, let's talk about that. The civil property dispute of Starrett vs. Benson had none of the theatrics of a criminal docket, but it was still plenty interesting in how Judge Aaron J. Gauthier unpacked the legal tangle. At its heart, this was a fight over a cabin, an old deed, and whether decades of casual family use could be spun into ownership rights. On the plaintiff's side, attorney Kevin Cleaver laid out the clean argument. The deed in question was never delivered or recorded before the grantor's death back in 2000. That makes it legally ineffective. Full stop. His clients were named in the will, not the defendant, so title should rest with them. He also pressed that the defendant hadn't meaningfully contributed to upkeep over the years, undercutting any equitable claim. To his credit, Cleaver kept it simple. When the law is on your side, there's no need for flourishes, counsel. Kurt Thornblade tried to push back with every angle available. He floated theories about the deed being held in escrow, or that it amounted to a kind of testamentary statement, basically an informal codicil to the will. He even leaned on adverse possession, suggesting his client could tack on to the family's communal use of the cabin over the years. The problem? The defendant himself had admitted under oath that he didn't even like spending time there. Never stayed overnight and wasn't around for most of those years. It's hard to claim exclusive, hostile possession of a property you barely used. Judge Euling cut right through the noise. He found no evidence of escrow, no testamentary intent in the deed, and no support for adverse possession or acquiescence. He pointed out that the will controlled, and under Michigan law, title to real estate passes at death to heirs or devisees. Since the deed was a legal nullity, the plaintiffs alone inherited the property. The defendant's counterclaims were dismissed with prejudice, and the judge ordered him to vacate the premises immediately, while holding him responsible for any waste or damage. The ruling also clarified that the plaintiffs would hold title as tenants in common under the will, which had always been the proper outcome. The overall tone deprofessional, with both attorneys presenting their theories without drama. Judge Gauthier kept things orderly, asked sharp, clarifying questions, and issued a detailed, grounded ruling that left no ambiguity. If anything was entertaining, it was the mismatch between the defense's inventive theories and the stark factual record, proof that sometimes no amount of legal creativity can fix a bad set of facts. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,